Welcome back to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. We're pleased to welcome Ted Frank, Director of the Center for Class Action Fairness at the Competitive Enterprise Institute. Ted, welcome to the show.
Thanks for having me.
Ted, among other things, some of which might not be repeatable on the radio, you've been called the indefatigable scourge of underwhelming class action settlements. How did you earn the lifelong enmity of so many powerful lawyers?
Well, I've started this organization called the Center for Class Action Fairness, which is now part of the Competitive Enterprise Institute. And we've gone in and protected consumers and shareholders from the predations of lawyers in class actions, who very frequently the lawyers structure the settlements to benefit the lawyers and not their putative clients. And they've extracted billions and billions of dollars of wealth from everyday people. And we've gone in and gotten courts to sort of change the way they look at these things and be more skeptical of what the lawyers are telling them. And in the process, we've won tens of millions of dollars for consumers and shareholders. And in cases where we've objected, courts have vacated or reduced nearly $300 million in attorney's fees.
Do us a favor and lay out some basics so we can understand the fundamental machinery of class action suits, both as the law normally intends and then what actually happens in practice.
Certainly. The idea of the class action is that you have a group, a class of people with identical or nearly identical claims, but it would be too small and too uneconomic to bring them individually. So if you can bring them in the aggregate and group these identical claims together, you can take 1 million people with $10 claims against their cell phone company, and you can turn it into a $10 million lawsuit, and now it's feasible to try and to bring that litigation and to remedy the wrongs that might have been done to these individual consumers. Unfortunately, what happens in practice is that these cases rarely get tried. They get settled. And then in the course of the settlement, you have the class action lawyers not only negotiating the relief for the consumers that they're representing, and one of the unique aspects of American class actions is that the class members are involuntary members of the class. Everybody is sort of grouped together under the bailiwick of the attorney who found the case. But they're also negotiating for the attorney's own compensation, and that just creates this tremendous conflict of interest where the attorneys have the sort of perverse incentive to structure the settlement to benefit themselves, but not their actual clients.
So in many cases, the lawyers get cash and the consumers get coupons.
The consumers get coupons, or sometimes worse, they get nothing. Or the consumers are supposed to be getting cash, but the settlement is structured in a way that the cash never actually gets to the consumers or the shareholders. And the problem is that while the system is designed so that the judiciary is supposed to be acting as a check on this and protecting the absent class members, the American legal system is designed to be an adversary system, and judges are used to having adversary presentation of issues. They're not used to or trained to be skeptical investigators of what they're being told. And when it comes to a settlement, suddenly you have both the plaintiffs and the defendants going to the judge and saying, here's a good settlement, please approve it. And the judge is not getting the adversary presentation. They don't have the resources to do a skeptical investigation. And they are happy to get rid of a complicated case that's clogging up their dockets.
And that's where you swoop in as an objector?
That's where we come in as an objector. We present the other side of the story. We act not even as a devil's advocate, but as a consumer advocate, as a shareholder advocate, and say, wait a second, here's what they're not telling you. They're calling this a $35 million settlement, but they've structured it so that class members have to fill out a 5-page claim form, and nobody's ever actually going to fill out that claim form, and actually there's going to be a lot less money going to the class. And under the settlement, they've arranged it so that all the leftover money goes to a charity picked out by the lawyers. And when that happens, it's almost invariably a good friend of the lawyers, but we don't know because they didn't say who the charity was. So there are all sorts of things you can do to sort of create the illusion of relief. And attorneys have been doing this for decades to create the illusion of relief that makes it look like a very large settlement. And the most notorious example, of course, is coupons, but things like giving money to charity instead of to the class, or creating an impossible claims procedure where no money actually goes to the class members. or creating the illusion of injunctive relief without actually changing anything that the defendant is doing. All these things that you can do to sort of exaggerate the value of the settlement to justify really big attorney's fees. But because the class isn't getting anything, what's really happening is that it's a much smaller settlement, but the attorneys are getting 80, 90, 100% of the actual proceeds.
You know, the large class action suits often make the news, and we all remember the Vioxx case. I understand you were involved in the early stages. Remind us how plaintiffs' attorneys managed to walk away with over $1 billion in fees on that one.
Well, the Vioxx cases weren't so much class actions as mass actions. Those were individual suits. But what happened there was that Merck was confronted with tens of thousands of different suits and eventually had to create a big pot of money to make all the litigation go away, because it would have been cheaper to just, here's the pot of money, you guys split it up, than to sit and fight every individual suit. Even though Merck won almost every case that actually got presented to it, with a handful of exceptions, most of which they won on appeal, Merck eventually paid billions of dollars to get out of this elephantine mess of litigation. And that left over $1 billion to be divided up by attorneys, many of whom never brought a winning suit, but were paid just simply because they were able to sign up clients.
That's real jackpot justice.
That's exactly what happened.
Cars are back in the news. I want to ask you about that again later, but I certainly remember something that was called sudden acceleration syndrome, which turned into something of a hysteria and a big lawsuit.
I mean, it's a very fascinating phenomenon. What happens is there's something called pedal misapplication, and it happens to almost every driver at some point or the other. You reach your foot down, you think you're hitting the brake, and you hit the accelerator, and 99% of the time you do that, you immediately recognize what happens and you move your foot. But there's that other tiny percentage of the time you think you're hitting the brake, you're hitting the accelerator, and you panic.
You freeze.
You have this cognitive disconnect. Wait, I'm hitting the brake, but the car is speeding up. I need to hit the brake harder. But because your foot is on the wrong pedal, the car speeds up instead and goes faster and faster because you're hitting the pedal harder and harder, but all you're doing is speeding up the car because you've hit the wrong pedal. And again, this cognitive dissonance. Drivers don't want to admit to themselves that they've hit the wrong pedal, and they think that the car magically did this to themselves.
They blame the software, didn't they?
Now they blame the software. In the 70s and 80s and 90s, they were blaming the cruise control, which was a new device, and say the cruise control automatically set itself off. And now that cars are more and more electronic, they blame the software. But the fascinating thing is, if you look at the demographics, who the victims are in sudden acceleration cases, it much more frequently affects short drivers than tall drivers. It much more frequently affects elderly drivers than younger drivers. And if it was software, you would think it would affect everybody equally. Or if it was especially evil software, you think they would go after the young people first because they would be the greater threat to the eventual computer takeover of the world. But in reality, what's happening is it's a pure human factors thing. The software doesn't know the difference between short drivers and tall drivers, but short drivers are more likely to hit the wrong pedal because it's harder for them to reach the pedals. Elderly drivers are more likely to react slowly when they hit the wrong pedal or become cognitively confused. So what happened is you had pedal misapplication, and it happens to all cars and all types of cars. But when you get a hysteria,
you attract lawyers.
And you get people talking about sudden acceleration in a particular type of car, then people retroactively remember things. And, oh, I had a car accident. It must have been sudden acceleration. And it becomes a self-feeding phenomenon because more and more reports come in on quote-unquote sudden acceleration, or you have accidents and nobody knows what caused the accident. And then after the fact, somebody decides, oh, if I sue the car company, I can blame sudden acceleration.
And now not only is the car company dealing with a lawsuit, but they're being tried in the press.
And they're being tried in the press, and you have lawyers who have the incentive not to get to the truth because the truth wouldn't get them a paycheck, but to find a guilty party and to make up a story And in a world where Aaron Brockovich is a lionized hero, the sort of conspiracy theory that evil Japanese car executives are hiding gremlins in the software that are killing people becomes very concerning. And Toyota did have a couple of incidents involving dealers that had installed the car mats in the wrong way or the wrong type of car mat, and the car mat caused an accelerator pedal to get jammed. And there was a very horrific 911 call of somebody who had one of those jammed accelerators, and they died in a horrible crash. But that wasn't software, and that wasn't what everybody else was suing over. But the media didn't distinguish between the two or preferred the interesting narrative.
So, Ted, you've also been involved in some video game cars. I understand there was a lot of interesting litigation around something called Grand Theft Auto.
That was a 2005 to 2008 lawsuit. That's actually what got me into sort of the class action objecting game, because it was a video game I owned, and I was a member of this class of video game purchasers who were supposedly injured because the game was slightly more risque than had been advertised, and they wanted to claim that this was consumer fraud. And it was one of these bogus settlements that I now spend my days objecting to. The attorneys were going to get $1 million, and the class would be allowed to make claims, but the claims process was such that, in fact, the class was only going to get a total of $26,000.
The whole class?
The attorneys were going to get 40 times as much as the class. And I had the idea that, I'd been writing about the class action problem and the problem of attorneys ripping off their clients. And I thought I could get some publicity for that if I went in and objected on behalf of myself and drew attention to the bad settlements that class actions were generating.
So what happened next?
So I objected. We got lots of publicity for that, much more publicity than I'd ever gotten for writing a law review article or a white paper about class actions. But more importantly, the judge looked at the class action, looked at the settlement, and said this shouldn't go forward, and decertified the class. And with very little work, we knocked $1 million of fees out, or relatively little work, I guess. Certainly much less work than writing a law review article. And I realized that I could talk about change, or I could actually go out and do something to change the way class actions were being viewed by judges. And I decided to find other people who were being ripped off by their lawyers and go after bad class action settlements.
So what are some of your favorites?
Well, I'd mentioned the baby products case, and that was supposedly a $35.5 million settlement.
Remind us what that was.
It was an antitrust case against Babies R Us, and they were supposedly doing things to artificially raise the prices of particular baby products like cribs and strollers and car seats. And they settled for $35.5 million, but the settlement was structured in a way that the class wasn't actually going to get any of the money. There was a 5-page claim form that you had to fill out. You had to remember your receipt and all these other details. So the class was actually only going to get less than 10% of that money, and most of it was going to go to the lawyers or to an unnamed charity that was probably also going to be related to the lawyers. And over the years, we've objected to a number of settlements where the money goes to charity, and it's just astonishing how often it's the alma mater of the lawyers or a charity related to the lawyers or the lawyer's ex-spouse's charity. And that's partially because lawyers prefer money going to other lawyers than to class members, and partially because it's a way to sort of double dip. You can send out $3 million $10 checks and you probably won't even get a thank you note. Or you can go and hold a big ceremony of an oversized check to some really grateful charity and get your picture in the paper.
Some people would claim that as long as wrongdoers are punished, what difference does it make if the money ends up going to someone else's charity?
That's certainly the argument we face in response. And the answer is that lawyers have a duty to their clients, and they should be trying to get the money to the clients. And if courts don't force them to try to get the money to the clients, and instead let them double dip and give money to their friends, the money is never going to go to the clients. And what we found is that when courts actually say, you, the attorneys, aren't going to get paid unless the money actually goes to the class members, suddenly
it gets there.
They discover all sorts of ways to actually get money to class members. So in the baby products case, instead of $3 million going to the class, it's now almost $18 million going to the class. We made a $15 million difference. And we have another case, we got a settlement thrown out, and the class was going to get $900,000, and the attorneys were asking for $4.5 million. The court threw that out as a selfish settlement designed to keep money away from the class members. And now they're actually going to directly mail checks to the class members instead of a complicated claims procedure. And we see that in case after case after case. If you force the attorneys to actually consider the interests of their clients, they will structure the settlement to get money to the class members.
So, Ted, we've got a class action suit in the making now. Volkswagen has recently admitted to cheating on their emissions testing software. This is certainly going to affect the value of people's cars, and no doubt there's going to be a lot of litigation. You want to comment on how that's likely to unfold in the months and years ahead?
Certainly, and that's precisely the sort of case that the class action system was designed for. People bought a certain type of car with a certain type of performance profile, and now after Volkswagen does whatever fix to make sure that the emissions comply with the law, you're going to get it back, and the gas mileage is going to be lower, and the torque's going to be lower, and it's not the car you're going to have bought, and you're entitled to damages for that in most states. And that's exactly the sort of case that class actions were designed for. You know, it doesn't make sense for you to sue for $1,000 in difference in car value, but if you can bring together 1 million Volkswagen owners, now it's economic to bring the case. The problem is we have, I think the last count was there were over 175 class actions pending. And the reason why there are so many pending is because these suits are enormously lucrative for the attorneys. Nobody is going to notice that, wait a second, it was third parties who uncovered it, and Volkswagen admitted the wrongdoing, and now government investigators are going to do additional research, and the lawyers haven't really added that much to the process. So what you have are all these lawyers fighting over the rights to divvy up a $1 billion settlement and then claim $100, $200, $300 million of that for themselves for relatively little work.
How does that kind of money translate into hourly fees?
That's the interesting part, because lawyers do a lot to exaggerate what those fees are. They do things. We had one case where they said, look, our hourly fees are $550 an hour, and we're entitled to some sort of multiplier for the risk we undertook. And we did some investigation, and it turned out that all these supposed $550 an hour lawyers were really $25 an hour temps who were just clicking buttons on a computer and not doing any substantive legal work. And they were just churning. They were just, they billed millions of dollars to these $25 an hour lawyers at $550 an hour. But much of the work they had done was after the case had settled, and there wasn't any actual risk, and it was just there to sort of exaggerate their fees. And there were other cases where the attorneys say we're entitled to a huge multiple of our hourly fees because we undertook all these risks and we did some investigation, and it turns out that they win 60% of their cases. So there really isn't that much risk, enough to get a little bit of a multiplier, but these people are asking for over $5,000 an hour.
And is there any kind of a legal penalty for bad behavior on the part of class action lawyers?
Well, that's the problem. What we have found is that the class action lawyers are all too often playing a head game of heads I win, tails don't count, and we get a do-over. So they come in and they make the request for over $5,000 an hour, and they lie about whether or not they've been using $25 an hour temp attorneys. And if they get caught, the judge just awards them what they should have been awarded in the first place, or sometimes even more than that. The judge will split the baby and cut their fees a little, but not a lot. And there's no ethical penalty for that, and we're hoping to change that. We're hoping that now that we've caught a few people red-handed, the next law firm that we catch red-handed, that the courts will actually impose some sort of sanction rather than just saying, oh, we caught you asking for $100 million instead of $70 million, so we're going to give you $70 million now. Because then there's no incentive to not just play with house money and ask for the $100 million to begin with.
So, Ted, if you achieve the vision you've laid out for the Center for Class Action Fairness, where do you expect to be in 10 years?
Well, it would be nice if we put ourselves out of business. If judges were so finely attuned to the problems of class action, settlement conflicts of interest, that They were doing the investigation that the system designed for them to do, and there was no need for us to come in and catch attorneys being bad actors, because the attorneys wouldn't be bad actors because they know they would be punished by judges and that they would invariably be caught. I'm pessimistic that we can get that far, but we're certainly making a difference, and the settlements we're seeing in 2015 are much, much better than the settlements we saw in 2009 when we started this, and we're winning tens of millions of dollars for class members, and we'll continue to do that.
Well, Ted, thanks for being on the show, and good luck putting yourself out of business.
Thanks a lot.
That was Ted Frank, Director of the Center for Class Action Fairness, here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Real Clear Radio Hour is produced in conjunction with Real Clear Politics, America's premier independent political website. Real Clear Radio Hour is a not-for-profit, donor-supported program now broadcast in 11 cities and online. To make sure you don't miss any of our shows, sign up for updates on realclearradio.org, where you can also find a growing archive of over 180 interviews with guests like venture capitalist Peter Thiel, Russian dissident and former chess champion Garry Kasparov, Gibson Qatar CEO Henry Juskowitz, futurist George Gilder, renowned chef and restaurant entrepreneur Danielle Belloud, former director of the CIA and NSA General Michael Hayden, education entrepreneur Sal Khan, and even Ralph Nader and Robert Reich. If you'd like to help us bring more guests like this on the air, please stop by realclearradio.org and hit the donate button, or contact us to become a corporate supporter. That wraps up our show for this week. Please join us next week, same time, same station. See you then.